Good morning. This clip relates to the second written assessment piece for LAWS12062 Alternative Dispute Resolution. It relates to your final take-home paper. You are to present your paper by the 8th of October at 11:45 p.m. I will not accept any late submissions. Now, the task will take you about a day. I recommend that you attempt to complete the task early to allow for contingencies and unforeseen events. However, you might decide to leave submission of your work until the evening it is due. Also, you may wish to prepare much of the document and then contact ADR practitioners when able to do so later in the week. All of that is a matter for you to decide. You are now required to assist Matthew. You will become immersed in a situation where you are required to work in conjunction with your supervising partner, Margaret. Your task is twofold. You need to write a draft letter to the client. In this, you outline a proposed strategy and make a recommendation or recommendations in relation to alternative dispute resolution procedure or procedures. Be practical. Think about what the client really wants to know in this letter. The client probably doesn't want to know about the historical perspectives that led to the introduction of, say, mediation. You might think it's important to explain some of the advantages and disadvantages of a particular ADR option to the client. Now, that's a matter for you. If you believe it is important to explain some aspect of the law in relation to the ADR aspects to the client, then do so. Do be as proactive and helpful to the client as possible. Provide the client with a particular proposal that is capable of acceptance and implementation immediately. In other words, go to the second stage of advice. If you recommend mediation, let's say, let the client know that you've made contact with an appropriate person and give some practical and necessary information such as the cost. Now, you may feel that it's necessary to describe the law in some way in the letter of advice to the client so that the client is properly informed and you have appropriately protected your firm. The memorandum to Margaret is an entirely different thing. It's your opportunity to explain the various options from a strategic perspective as if you would to your supervising partner, or as you would to your supervising partner. Now, this may cover some of the ground you covered in the letter to the client, or it may go beyond that. In the memorandum to Margaret, you should provide some of the legal justification to support your advice to the client. If you want to describe some legal aspects, this is probably your chance to do so. I leave it to you and your discretion as to how you use the allocated maximum of 3,000 words. Do have fun with this project. All the best.